And it also depends on the person who is going to perform the autopsy to say, yes, I'm taking the ability to look for other findings. If I find them, I will then report them. And it is often said that your medical or forensic autopsies are carried out in the interest of the public, therefore referring to the general welfare of the whole population. And this is somehow a misleading and confusing term, because in most cases, I feel that the interest is for an individual, because when we order the autopsy, we know what the findings are going to do, because we can find a cause of death that may be implicating a certain individual or can benefit a certain individual. So when it's said that it's for the public interest, the statement is a bit vague and confusing. Now, when you request a medical legal autopsy, it is performed on request by police or a prosecutor or the forensic pathology, and it is usually in unnatural or violent death, sudden unexpected death, unwitting death, and most importantly, what we're all interested about, procedure-related death. The aims and objectives of a medical legal autopsy. Here, obviously, we want to reveal the cause of death for the legal system or for justice system. We want to collect evidence and other evidence in order to provide information to reconstruct a chain of events in a criminal death. And we also need to illustrate these findings to a court of law. And sometimes we prefer to identify an unidentified body, which is why I said that external examination is more important in these cases. And last but not least, to evaluate suspected malpractice. Okay.
Dr. Brenda?
Okay. Yes. Now, forensic pathology autopsies are performed by forensic pathology officers. Sorry, the slides are now moving faster. And the role of the forensic pathology officers is therefore to conduct the autopsy and provide a report in a court of law. Now, sometimes these two types of autopsies might overlap with each other. And we have zones where we're not sure whether this is a forensic pathology autopsy or a clinical autopsy. And in those cases, like I said, most of the time, the departments will come together. For example, if we look at a case of a patient who is admitted in the ward for a certain disease, it could be hypertension, it could be diabetes, and the patient falls off a bed in hospital and he sustains a head injury and dies. In this case, you're not too sure if the head injury actually caused the death or the patient died because he had a disease. So it could either be medical legal autopsy or a clinical autopsy. So in such cases, we're going to carry out a medical legal autopsy because this patient had trauma. And if we rule out that injury was not the cause of death, the anatomical pathologist will then take over the autopsy and examine the body for the extent of disease that might have led to death. And this occurs a lot of times where we find that there is a dispute as to whether this is a medical legal autopsy or a clinical autopsy. Now, I think this is what everybody is interested in today. And most of the time when I give a presentation that is related to procedure-related death, there is a lot of anxiety and nervousness amongst colleagues, because obviously this sometimes may seem implicating. And this has led to the number of requests for autopsies, because a lot of our colleagues worried about medical legal issues. So if we look at the procedure-related death, it says that this is when death occurs following surgery. The role of the autopsy is to determine the cause of death and the impact, if any, that surgery had on the cause of death. Now, there are certain acts that are supposed to us as healthcare providers in terms of natural versus unnatural death. And most of these acts have been amended. And it's very important, colleagues, that you familiarize yourselves with this act, because we often find ourselves caught in medical legal cases, because obviously medical law is not part of our curriculum. So it's important that we familiarize ourselves with this act. So the first act that I need, or I want the colleagues to familiarize themselves with, is Birth and Death Registration Act. This is Act 51 of 1992. And specifically, it burdens the doctor to decide whether death was natural or unnatural. And it can ever be difficult sometimes to ascertain whether a particular death is considered natural or unnatural, or if an inquest is needed. And if there's ever a time where you feel that we need to always put it as unnatural so that an inquest can be performed. And, like I said, a prominent cause here is that most of us are not confident in making this decision as to whether this is, a procedure-related death or not. The Birth the Inquest Act, which is the Act of 1995, provides that in case of unnatural death, a medical legal inquest needs to be held, and this should include a post-mortem examination. And Section 2 and 3 of this Act also relate to the duty of any person to report the unnatural death, and the investigation of the circumstances should be carried out. Section 2 and 3 of the Act also states that any person who has reason to believe that any other person has died and the death was due to other than natural causes shall, as soon as possible, report accordingly to the policeman, unless you have reason to believe that this has been reported by another person. And subject to the provision of any law providing for investigation for the circumstances of death, any policeman who has received such a request is also obliged by law to make sure that there is an inquest that is going to be opened, and they must investigate or cause to be investigated the circumstances of the alleged death. To report cause to be the death of it to the magistrate and to the district concerned. So basically, this act says to us that if we suspect that there was an unnatural, this needs to be to the police, and the police needs to take it upon themselves to investigate, and they also need to report this to the magistrate. If the body of the person who has allegedly died from other natural causes is available, it needs to be examined by the district surgeon or other medical practitioner who needs to basically conduct an autopsy in this case. Now, the third act is the National Health Act, which is Act 61 of 2003. And in the act, the shall be deemed to be death due to unnatural causes, and these deaths are defined as follows in the regulation of the Act. Any death due to a physical or chemical influence or indirect and or related complication, and this would include procedure and anesthetic related death, as by nature they involve physical and chemical influence. What is important here, colleagues, is that there is no mention of a time frame or a duration of when this death has occurred. So it's a death that is due to physical or chemical influence. So it is important to note that there is no time frame that is put to this. So you can't say that the patient died 2 hours after the procedure or 24 hours after the procedure. We do not have time frames. And they also say that any death, including those deaths that will normally be considered to be death due to natural causes, in the opinion of the medical practitioner has been the result of an act of commission or omission, which may be criminal in nature. So, when we start discussing this with colleagues, and we will go into the Health Professional Amended Act now, a lot of colleagues then start saying that if I'm going to do a procedure on a patient and I know that their chances of survival is very low, then if this is going to be seen as a procedure-related death and there will be an inquest on it. But you need to be very careful with that, because then what I've just out for you, that an act of omission as well becomes a medical legal autopsy. So if you omit taking the patient to theater or to a procedure because you are worried about a medical case, then you might also still be liable to the death of that patient. So if the patient dies because we decided not to do a procedure, it could still lead to a forensic autopsy. Any procedure related, including anesthesia related death, as contemplated in Section 48 of the Amendment Act, also become an unnatural death. And where death is sudden and unexpected or unexplained, then those constitute unnatural death according to the Health Act. Now, the Amendment Act is the one that's becoming a bit of a challenge amongst healthcare practitioners. In 2007, Section 56 of 1974 was substituted by Section 48 of the Health Professional Amendment Act. And in this act, it states that the death of a person undergoing or as a result of a procedure of therapeutic, diagnostic, or palliative nature, or of which any aspect of such a procedure has been a contributory cause, shall not be deemed to be death of natural causes as contemplated in the Inquest Act of 1959 or the Birth Act of 1992. So this is very vague and it is very broad. It encompasses every procedure that you can think about. And it has become a problem with a lot of people being about taking care of patients. If you look at a procedure itself, a therapeutic procedure could be inserting a drip on a patient. A diagnostic procedure could be going to theater just for an invasive radiologic test. So all of those are now being placed in this unnatural death. And, when you read further in the Act and you try to understand why the Act was amended, basically they have decided that, this anesthetic-related death, which were what we used to call this death, very complicated, and it was complex in terms of when do we deem one to be an anesthetic-related death. And I still remember well when I was practicing as a registrar in anatomical pathology, we used to sort of look at 24 hours as the cutoff period. And there's actually no act or no law in South Africa actually that we need to look at 24 hours. I think it's something that we just worked out as 24 hours. And we then also had whether the patient was regained consciousness or not. And if the patient had regained consciousness, it will not be an anesthetic death, even if the patient died within an hour of regained consciousness. And what had happened is that a lot of unnatural deaths were left uninvestigated, and which is when this broad encompassing term came out in 2007, and they called it a procedure-related death. And it is a very difficult act to practice, because though we're looking at saying that we want to protect patients. There's also an increase. I mean, there's a bed to forensic pathology if you think about the number of patients that demise following a procedure. You would almost say all patients that have been hospitalized fall under procedure-related death, because if you put a drip in a patient who has meningitis and the patient later demised, one can still, though the patient had a disease, the one drip that was inserted. So the Act is very vague, and there is an article that I'm going to refer you guys to towards the end of the presentation, which published Prof. Mba from Department of Forensic Pathology in UKZN, where he's actually recommending that we sort of look at the term and try to amend it. And I think they have already written a recommendation to the HPCSA to say that, can we look at redefining this term? It is very broad, and it doesn't really assist us in terms of which cases should we be sending to forensic pathology department. In his publication, he says that we need to look at the owners of decision to the forensic, and this will be in consultation with the treating clinician, where the clinician can sit with the forensic pathologist and use CAS that this is the case, this is what happened. The patient was to theater, this is the procedure that was done, and the patient later demised, and we can then have a discussion as to whether this is medical legal or not. It is a very daunting act, and we need to carefully consider it and be able to interpret it so that we can make it easier. And all the regulation and acts regarding healthcare professionals are readily available, guys, on the government gazette. And we need to acquaint ourselves with this. You need to read this act and know what the acts are saying so that you're able to cover yourselves, especially we're sitting in an era where there's a lot of law firms that are out there to represent patients. So you need to know when to request, a medical legal autopsy. Sometimes that might just be an investigation that is going to actually save you. And the Act regarding procedure-related death has changed recently, like I said, in 2007, and it comprises a more description of possible procedure-related death, certain deaths that you might have thought were classified as natural death in the past. In this new act, you will see that they have been classified now as unnatural. And as of deciding which procedure-related are unnatural, with this amendment, act has been removed from the managing doctor, and then it includes all such death. So therefore, what they said when they had this, we're taking the onus away from the doctor. You don't have to decide whether it was 24 hours, whether the patient remained conscious or not. You can just, if the patient had a procedure, you can send it to forensic pathology, an inquest will be open, and an investigation is going to be done. Most of us, intimidating, but I think on the other side, we need to look at it on both ends. You need to look at it as both a clinician, and, you can be the other side where a family member was taken to theater and the family member did not make it out of theater. So in that case, you also want to know what happened. So we need to look at both to say that as part of our responsibility as treating healthcare providers, we also need to ensure that we provide a safe environment for both our patients. So, which is why we need to make sure that all the procedure-related deaths are investigated. The legislation on procedure and related death, which is the last reference there, is an article that I'd like colleagues to familiarize themselves with. Very interesting that was published by Prof. Mudiva and his colleagues. And in this publication, they literally go into the new Amendment Act and discuss how came to the new Amendment Act, talking about different studies which were performed, especially on maternal death, and the findings which led later to of an act that was encompassing of all procedures, and which might not be favorable to practicing healthcare providers as well as forensic pathology departments. And they, at the end, give a recommendation where they say that nature and extent of medical investigation must be left to the discretion of the state pathologist or magistrate of the district in which the death has occurred. So you will submit your files to the pathologist before an inquest is open, before we decide that this is a medical legal autopsy. The file will be examined meticulously and a decision made as to whether this is a medical legal or not. They further also say that an autopsy can also be performed before we decide if this is medical legal or not. And for that, we can then say this is a medical legal case, and then an inquest can be open. But this remains suggestions until HPCSA have looked into and maybe amend the amended act. That is all I had for this afternoon. Mainly, and this is a QR that the colleagues need to scan.
Yeah, that's if they've got any questions, they're welcome to scan the QR code. I see there was something in the chat function. I just want to get in there quickly. I don't know if you can see from yours.
Brenda, if I can ask it to you, it's asked by one of the senior registrars. It goes, so if a neonate with necrotizing enterocolitis dies following a diagnostic laparotomy, which shows an NEC totalis, that procedure would not have contributed to the death, as the death was inevitable from natural causes. Should that child have an autopsy just because they had a procedure shortly prior to the death?
Thank you. Yes, Doc, that child will have a procedure. That child is going to autopsy. The procedure-related death encompasses all procedures. And if you, the treating, can I see, and look, if we can stop sharing the screen, I just want to see the comments that are coming in so that I can engage with everybody. So if I could just give an example to the doctor that asked the question. We had a presentation and a meeting with forensic pathology officers, and the example that was given to us was a child that has hydrocephalus. And in this child who has hydrocephalus, the child is taken to theater, and we then in a VP. And this child is monitored in OPD, and later on, years down the line, child develops epilepsy and dies from status epilepticus. And the question was, is this a procedure-related death or not? And what we were told by the forensic pathology department was, yes, this is a procedure-related death. This child had a procedure, and they were trying to show us that you cannot put a time frame to the procedure. Even if this child died 5 years later, this will be a procedure-related death. So the answer to your question is yes, the child was taken to theater. There was a procedure that was done, and this will still be doomed to be a procedure-related death according to the Amendment Act. So that autopsy will go to forensic pathology department. I know that in most departments, what happens, there will be an engagement between the surgeons and the anatomical pathologist, and in consultation with forensic pathology department, a decision is then made if it's a medical legal case or not. But if you go through the act, this will be a medical legal case because that child had a procedure. So the question that you need to ask yourself is that, did the procedure somehow contribute to the death of this patient? Should you have left this child? Would the child have died at that point? And also remember that you omit to do the procedure because you think that the child will not survive the procedure. The Act says that an act of omission then dooms the case to also be a medical legal autopsy. And it is why this has spiked a lot of discussions, because the feeling is that, it was not consulted with experts in terms of, the pathology units, in terms of saying, do we sort of take responsibility of being able to do all this wide range of, procedure-related death? It could be palliative, it could be diagnostic, it could be therapeutic. Anything that has to do with a procedure will have to have a medical legal autopsy performed. I think there was another question. I can't see that box, Menlu. Right.
Okay, do you need me to stop the presentation?
Yes, you can stop the presentation. So
Does that help you?
Yes, I see. Yes, I can see that now.
Okay.
Yeah, so it will be considered unnatural. The current practice is not to do autopsies on COVID patients. What about maternal death who has anesthetic? Surely it should be filled. Okay, so the COVID patients, some of them autopsies are done in these patients. Obviously, this is academic purposes, to see the extent of disease, and it's also for training reasons. The issue of maternal death, it's something that we've had long discussions on, and the article that I've asked you guys to look at also shows you a lot of studies where, of maternal death and anesthesia. So if the patient dies following a procedure, if this patient goes to theater and anesthesia was administered to the patient and the patient dies, this will be a procedure-related death, because obviously surgery was performed and we also gave patient chemicals. So if you look at that act, it says that if we administer chemicals to the patient, this is going to be a procedure-related death. However, I think the biggest challenge here with amended act is that it doesn't give us a time frame, like I said. You can't say that I gave anesthesia last week, so this cannot be, an effect of the anesthesia. And you'll see that in the recommendation of Prof. Madiba, in the first recommendation, he says that all death within 24 hours of administration of anesthetic or performance of a procedure must be subject of a medical legal investigation. And he also suggests that we keep the two terms, both anesthetic related, procedure related, separate, and we can then further deem that the anesthetic related death should be given a certain time frame, and we could say it's anesthetic related or it was a contribution of the anesthesia. So the act still needs to be unpacked, colleagues, to unpack it so that we can understand what it means and we don't end up sending all our cases to the forensic pathology department.
Thank you. Thank you very much, Brenda. Is there anybody else who's got questions for our speaker? I just wanted to clarify, generally speaking, just to make sure that the pathologist and anesthetist are on the same page, if a patient should die on the table, we remove nothing. So we don't take out the ET tube, the drip, we leave it as is when the patient died. Is that correct?
Yes, that is very correct. Especially medical legal autopsies. So part of the external examination includes us examining all those, everything that was inside to the drip site, the ET tube. We need to check if the ET tube was where it's supposed to be. As you will know that with that is related to anesthesia, most of the time, I think a high number of those are due to failed intubation. So everything should be left in the patient when the body goes to sharing.
Thank you, Brenda. I'm sure the anesthetic body is saying no. There's no such thing as failed intubations. We're the best at the job. I see Claire Buck has got her hand up.
Hi. Yeah, sorry. Palesa, following on what you're saying here, I think that's just something quite interesting because quite often if there is a DOT, then the rest of the team actually immediately start removing some of the equipment, including the ET tube, because there was an argument made that when the body is transported during the ET tube is gets moved or dislodged, and therefore it will be seen as being too deep. Or I see Boyan's also just mentioned that. So even so much as ET tubes, NG tubes, I've seen them being removed. I think it's just something we must now just clarify. So sorry, thank you.
So in terms of the ET being displaced, either, especially if it's, dislodging it from the trachea to the esophagus, remember that there are certain things that we also look at in terms of whether the ET tube was in the right position. So obviously, we also look at, the marks, the hemorrhagic marks you'll find in the trachea. So the ET tube was never in the trachea, you're not going to see those marks. And in the forensic concept, we need those insight to be able to see whether they were in the right location or not. So I am not for removing them, because if you say you're moving them because they can get moved, it's sort of already, I'm gonna put it in, it's like already trying to sort of cover up yourself to say that I'm, in case it moved and it's somewhere else and the report says it was somewhere else. But I need you guys to understand that when we record the finding of the instruments that were used, it's not that we're just going to say that it was found here. We will also look at, the marks. I have done medical legal cases on cases where it was failed intubation, and we don't just look at the positioning only. There are other factors that we look at to say that it looks like the initial intubation was in the trachea and the tube has been dislodged to this area. So those are the things we look at. And remember that this is not just a gross examination, it's also a microscopic examination where sections will be taken to also show that, yes, there was mucosal hemorrhages, there were congestion in that area to confirm that the tube was initially in the right place. I don't know if that answers your concerns.
I think it does. Thank you. Dr. Bruno, do you have a question?
Yes, I do. I'd like to know if we refer a patient, obviously we all involved with procedures in medicine, and we refer a patient for an autopsy because of the procedure that we have undertaken. The pathology department obviously cannot do all these autopsies. There will be far too many, and we know that already. Who takes the responsibility? Who is now going to be responsible for this autopsy not having taken place? Will the pathologist indemnify the physician who referred that patient or not? Because obviously the physician is culpable, and possibly also the pathologist. Who takes responsibility for not having done that autopsy?
Thanks, Dr. Breno, for your question. It is a very, it's a concerning situation for the both of us. Like I said, that it's a lot of procedure-related death. And if we had to say all of this needs to be sent to forensic pathology, we will not be able to cope with these numbers. And especially because, if you look at the scope of this for forensic pathology, especially in Bara, for example, the number of trauma cases that they have to do, not even looking at your cases that will go into the hospital, it's quite a high number of cases. So, obviously, for a physician, you need to request the autopsy. Say that there's a procedure-related autopsy. I'm requesting it, and what's seen happen in the hospitals where you've got forensic pathology department like your hospital, then the police will get called, they will come, they will investigate, and they usually decide with consultation with the forensic pathology officer that this is the case, do we take it as a medical legal case or not? And if the forensic pathology decides that it's not a forensic pathology case, needs to be documented in the file that an autopsy was requested, and in consultation with this forensic pathology officer, it was decided that this is not a medical case. Because unfortunately, you as practicing clinicians, you need to cover yourself to say that I did request this autopsy. However, because I've had a lot of clinicians that we do request those things, and police come and say, no, it's not a medical legal case. So unfortunately, those incidences needs to be recorded in the patient's file to cover ourselves to say we did request. And in consultation with this department, with this forensic pathology officer, it was decided that this is not a medical legal case, so that the forensic pathology officer can take responsibility of making that decision to say that I took responsibility that this was not a forensic investigation. Because unfortunately, a lot of families are now, being hyped up by law firms and all of that, and anything that happens in the hospital will end up being investigated.
Yes, but unfortunately, the family decides to sue the doctor concerned, the anaesthetist, for argument's sake. They will sue the anaesthetist and also the pathologist, and both will remain liable. In our insurance, this is not covered. And I think that people should be aware of this, that when you do take out medical insurance, you specifically look at this point about referring causes for unnatural death, because we're all involved in palliative procedures and we are all highly at risk. So for all of us, I think we should insist on our insurances making this available to us, or actually specified. The family will be able to sue both doctors, whether you inform them, the pathologist, or not. And thank you for your response. Thank you.
And I think, Dr. Breno, it's very important that I think we have left most of the decisions to be taken by people that are not involved in in managing patients. And especially if we look at this Amendment Act, it's a pure indication that shows that we as healthcare practitioners were not involved actively in making these decisions, because the act is really not an act that is a positive act at us. And we are kind of hoping that with the discussions that are taking place, the act can be more clearer. And if we can then say in that act that there will be a consultation and a decision will be taken, clearly, if the act writes that the decision is going to be taken by consultation of the pathologist and the clinician, it might alleviate the problems. But it does not say that. And you're right to say that most of the covers that we have do not cover us for such. And we need to be aware of that.
Thank you.
Thank you, Brenda. I'm sure there's multiple other questions, but we'll save them for another day. But thank you for that comprehensive look at the other side of a field that we don't really know a lot about. Thanks. Thank you very much.
Thank you very much, Palesa, for having me. I think the only thing that I have for the colleagues is that we need to familiarize ourselves with the acts that are available. Unfortunately, we don't learn medical law in our institution, and it's something that we need to sort of consider as part of the curriculum. Familiarize yourselves with the act, and also familiarize yourself with the type of legal cover that you are taking. Make sure that whatever you are paying for, it's something that covers, and it's most important for you. I still remember that when I took my cover, I had to go back and check, what am I covered for? What is important for you? For me, my eyes are very important. If I lose my eyesight, I will not be able to practice. So it's things like that that are very important. When you take a disability cover and you check, they say that they will cover for, an accident and an amputation, whereas you can still function with an amputation. So you need to look meticulously at things like that to say, what is more important for me and what is this covering? So thank you very much for having me, colleagues.
Thank you. Thanks very much.
Thank you, Palesa. Thank you very much, everybody, for your time.
All right then, bye.
Thank you.
Our next speaker I see has joined us. It's Shamal Ramsa. So Shamel, I mean, I think I learned a lot about Shamel when I asked for his CV, quite a lot of the stuff I wasn't aware about. So he's done a BSc honors, he's got a master's in medicine, he's got a PhD in philosophy. During his studies, he was also inducted into the Golden Key International Honors Society for Academic Excellence. He has published multiple stuff in fields of hypertension, preeclampsia, phytotherapy, infection prevention, and has presented and research findings at various local and international conferences. He served as an academic at the University of KwaZulu-Natal and later joined UJ, where he lectured on physiology and anatomy. Post-academia, he then explored a corporate interest where he joined 3M. I think this is the first time when I met Shamel was when he was with 3M as the Scientific Affairs Manager for Infection Prevention Division. He later added on to this role as a National Sales Manager, and during his tenure at 3M, he served as a chairperson of the CSSD Forums of South Africa, the Gauteng chapter. He's a chairman of the 3M Technical Forum of South Africa. He's the acting chairman of an acronym I'm not going to go into of South Africa, and he currently holds the position of Chief Medical Officer at Augustine Medical and serves as the National Chairperson for Mediation in Motion Mediators. And that's how I most recently met Shamel again. And that's why he's speaking to us today about the role of mediation in medicine. Thank you.
Thanks, Dr. Mokhane, and good afternoon, ladies and gentlemen. You know, normally after an introduction like that, I get a few hands going up on screen. And normally the first question is, how old are you? And, you know, I normally like to say I'm normally just as old as the lady I'm with, but actually I'm just 39 years old. So thanks for having me, Baby Palesa, as she has so affectionately become known to all of us in Mediation in Motion. And I'm going to use the next couple of minutes to talk to you about mediation and the role it plays, especially in the medical fraternity. With your permission, can I share my screen?
Please do. Shamel, your speaking comes in and out a little bit.
Let me just see if I can.
I can hear you. It comes in and out a bit.
All right. Are we clearer now?
Perfect.
All right. I should be on by now, right?
You are?
Thank you. All right. So like I said, I'm going to use the next couple of minutes to talk to you guys specifically about medical legal mediation and the role it has to play in South Africa. So as you would have heard from my little introduction, that I'm the national chairperson for a group called Mediation in Motion. And basically, it's an organization that serves to train mediators specifically in the areas of practice. So, for example, we have now trained about 97 clinicians, I'm talking about medical doctors, in the role of medical legal mediation. And really, the purpose behind this is we want to have experts within the medical fraternity helping to resolve medical legal matters. What a great idea, right? Now, I'm going to take you slightly back into the history of medical legal matters in South Africa. And more importantly, why there is such a crucial need for mediation. Now, the information that I'm going to share with you is probably not uncommon because you guys work in the field of clinical practice, and you guys will know for sure that medical legal litigation, sorry, is that a question? Feedback? All right, so you guys would know that medical legal litigation is on the rise. I mean, if you go to any one of our organizations, our associations, this is quite a hot topic. It's normally addressed at most meetings where we are seeing a sharp rise in medical legal claims. And of course, the reason, and we're gonna be absolutely honest during this presentation, is that the medical fraternity, especially the public healthcare sector in South Africa, opens itself up for these claims. Now, if you can consider or cast your minds back to the road accident fund and how it became such a cash cow for advocates and attorneys who were looking to make money off a set fund that was dedicated to people who claimed from road accidents. And you guys know exactly what happened with the road accident fund, right? Basically, it was exploited so much that there is no fund that's left over, or there's very little that's in that fund. Now, because that avenue of income had been sort of throttled, the kind attorneys and advocates, and please bless their hearts, I have nothing against attorneys and advocates, but they have to look for an alternate source of income. And of course, they started targeting the medical arena. Now, for those of you that do work in public healthcare hospitals, can bear me out here and maybe testify to the fact that if you walk in the corridors of our public hospitals, and this happened to me while I was walking through Hospital Street a couple of years ago, where the guys actually approach you with their business cards and say, have you been wronged by this very hospital that is meant to be treating you? Here's my business card. Let's take them to court. You stand a chance of winning so many million. And of course, with the rate of poverty in South Africa, it's like music to their ears, all right? And of course, you find this not only in the public sector, now the private sector has jumped, or the private hospitals have been targeted as well, purely because they've learned that these hospitals have specific funds now that's dedicated towards paying for these lawsuits and medical negligence claims. And if you guys don't believe me, you guys can switch on DSTV. I saw it the other night. Monroe Flowers and Formark, leaders in medical malpractice. Have you been wronged by the very, very medical practitioners that are meant to be healing you? There's others as well that are all over the place. And really, it shows that this market, and I'd like to call it that, a market for medical negligence, is really on the rise. Now, if we all agree to this, let's look at what impact this is having on our beloved healthcare environment. Now, ladies and gentlemen, the data that I share with you comes directly from the South African Law Reform Society. Some of you may have seen it, but just to show you how this has progressed. In the year 2010, 2011, right, when they looked at the amount of claims that was lodged for medical negligence in South Africa, this was directly from the Department of Health, it sat at 95 million in 2010, all right? And if you look at just 4 years later, all right, 3 years to 4 years later, 2013, 2014, it rose to 498 million, all right? That's almost a 500% increase in medical legal claims in just 3 to 4 years, all right? Now, before I share that point, does anybody want to guess? Maybe, I don't know if we have time, but anybody wants to guess what medical negligence or medical legal negligence claims or contingent fees sit at the moment in South Africa? Any guesses? All right, let me share this point with you. In 2019, it stood at 98 billion rand. 98 billion. And of course, this year, through our friends at the Law Reform Society, we learned that that amount sits at 118 billion rand in medical practice lawsuits, the contingent liability fees. Guys, that is more than half the healthcare budget. All right? And that is the reality that we live in. Right? We have over 118 billion rand worth of contingent liability fees sitting for medical malpractice in our country at the moment. Now, the total number of cases from 2017 to 2019 also shows a rise. So in 2017, there was almost 8,000 cases, but in 2019, there was 13,000 cases, which means that in just 2 years, more than 5,000 new lawsuits were filed with the Department of Health. All I'm trying to show you here, guys, is this is a hot market for making money. as you can see how it's grown in terms of cases and of course fees as well. So what does that mean? It's really a vicious cycle. Because if you can imagine, and let's focus on the public sector for now, all right? No hospital has a fund or a budget for medical negligence, all right? And of course, where does the money come from? It comes directly from the hospital budget itself. Now, when you get a claim, right, that comes directly from the hospital's budget. It means the hospital's budget is reduced, which means that the hospital has lesser money to spend on infrastructure. So whether it is something as simple as your anesthetic drugs, which we know are short in some of the hospitals, especially in Gauteng, and of course, it could be even your machinery, your anesthetic machines, but yeah, X-ray machines and so on. What does it translate to, guys? It means that if there's poorer or insufficient infrastructure and consumables and so on, it results in poorer service delivery. And of course, the poorer service delivery results in more medical legal claims. More claims, less budget, poor infrastructure, poor service delivery, and this cycle just goes on and on and on. And it's spiraling out of control, so much so that I'm confident it is going to cripple our healthcare industry in the next couple of years unless something starts to happen. So, what do we have to do? Ladies and gentlemen, we have to find a way of, firstly, mitigating these huge quantums that are being claimed for because of lawsuits. And we have to find a way of fixing this very quickly. And I'm going to show you further down the presentation why the emphasis on time is really important here. Because if anybody does follow this topic very carefully, you'll find that there is a backlog of lawsuits that need to go to court. And these things are going to take years upon years, if not decades, to try and reduce. So let's take a step back and let's look at an alternative way in which we can reduce these lawsuits and more importantly, how we can resolve the conflict. All right? Now, the first thing we need to understand, and this is really where I'm going to get into mediation itself, and what is the purpose of mediation and how it works for your understanding as well, so that you can all hopefully become advocates for this process of mediation. So what are the causes of conflict? Obviously, there's different expectations. Two different parties with two different sides of the stories, both wanting two different things. Now, I want to find out here, and I'm sure everybody's been in some sort of conflict, right? Whether it is with your spouse or someone at work, or perhaps a family member, right? And you start to realize that conflict starts off as a small little argument. And then we start to fabricate and we start to add fuel to the fire, so much so that it causes a huge flame in our heads, a huge fire where we can't see the other party's version of reality. And when you can't see their version of reality, you become blinded to the fact that you could also be wrong or that they could also be right. Depends on how you want to look at the matter. And of course, because of these different expectations, the conflict just grows and grows. Imagine just adding fuel to fire all the time. And the most important thing that I want to draw your attention to is whenever two people or two parties are in conflict, they almost always start to violate each other's dignity. And ladies and gentlemen, from our tons and tons of research on this matter, we find that the dignity violation is the biggest cause of conflict. Now, what does it mean to violate one's dignity? For example, if a clinician is being sued for some sort of malpractice, by the mere fact that you are opening up a lawsuit against him violates his dignity amongst his peers, where he is now deemed to be an inferior clinician, for the want of a better word. Or he's deemed to be not as good a clinician. And really, that eats away at his ego. It actually violates his dignity. In terms of a patient who was wronged, or maybe not always wronged, but has some sort of adverse outcome or something, that adverse condition, for example, let's just say if somebody needs a colostomy bag or something of that sort, right? It violates their personal dignity. And you find that it's these dignity violations really that causes this conflict, all right? Now, when you understand that, you will tend to realize how easy it becomes to resolve conflict. And I'm going to show you as we go along. So what is the effect of conflict? We already said this. We have two parties with different versions of reality. One person in their mind convinces themselves and their immediates that they are absolutely correct and the other party is absolutely wrong. Yet on the other side, you have the other party claiming the same things, that they are 100% correct. So we've got two different versions of reality. One story, one matter, one case, two opposing versions of the reality. Now, if we understand that there are two opposing versions of reality, it obviously gives us an opportunity to bring everybody or to align everybody onto a common story or onto a common version. And we find that in this technique of mediation, which is so scientific, that when we start to align each other's versions of reality, we start to open up opportunity for resolving it. And in fact, we're saying that there are benefits to conflict because it allows for transformation. It allows for people to change their mindsets and change their versions of reality and become more accepting to the fact that they could be wrong or that the other person could actually be right. And the most important thing, especially from a moral and ethical point of view, is that we have an opportunity to produce just outcomes. All right. So just outcomes, it means that both parties find themselves in a win-win situation. All right. Now, I want to quickly take you to the definition of justice. And this will help me, or will help us to kind of realize where we are standing at the moment with regards to litigation in South Africa. So you guys would have heard these terms before: litigation, arbitration, mediation. I'm going to kind of take you through very brief definitions of them and show you how each one differs, and most importantly, why we need to engage in a alternate mechanism of conflict resolution. So by definition, what is justice? Justice is achieving an outcome to a dispute or conflict that is, listen to this, morally right and fair and in accordance with the law. So that by definition is justice. It must be morally right and fair, and obviously in accordance with the law of the land. And that is what would produce or is meant to be a just outcome. I'd like you guys to keep that definition on the back of your minds, because I'm going to take you through two real cases where the parties underwent litigation. And I want you to apply this definition of justice to the outcomes of those two cases and tell me, or in your own mind, make up whether that outcome was just, whether justice was achieved. All right, so let's go on. What is litigation? By definition, litigation is a process where public officials decide cases by applying the law to their understanding of the facts and proclaim who is right and who is wrong. So let's think about this. A process where public officials, so this is your advocates, your lawyers, your judges, all right, they would apply the law, which is set in stone, our laws, right, to their understanding of the facts. So remember, in these cases, It is whoever presents the best story, the most plausible story, all right, that would convince these individuals, the judge or whoever is adjudicating, whether this person is right or wrong. But here's the catch-22, or here's the problem. With regards to this type of dispute resolution, somebody has to be right and somebody has to be wrong. That is how it works. So when you go to court, somebody wins, they were right. The person who lost, they were wrong. And we're going to learn that in conflict, it may not always be that way. It may not always be that one person is right and one person is wrong. It could be that both people are right, but there's just a different understanding of how right they are. But unfortunately, our law works that way. When a judgment is made, a judgment will state, Mr. A has won the case, and that means by law, they are right. Mr. B has lost the case, and by our law, they are wrong. So it really doesn't do anything for that conflict itself. In fact, it heightens the conflict, if you can imagine, because now somebody is telling you you are right, and the other person or the same person is telling the other party they are wrong. And of course, this can heighten the conflict. So litigation is just that, where somebody applies the law to their understanding of the matter and makes the decision on who's right and who's wrong. Then, of course, you get, oh yes, and when it comes to litigation, it's publicity prone. So any case that goes into court, it's open to public scrutiny. You can find information on these cases regularly on the internet, and of course in the media as well. Then you get an arbitration. An arbitration is a process where a selected person decides a matter by applying the law to his or her understandings of the facts and proclaims who is right or wrong. So exactly like litigation, right? They would listen to two sides of the story. Whoever presents the better story or the more plausible story would get the agreement of the adjudicator. And that adjudicator says, yes, you are right, you are wrong. The only difference is that it is private. So the contents of the case is not open to public scrutiny. It's kept all within the doors of that arbitration room. And once the judgment is made, it's full and final, and that's it. So litigation and arbitration, the only difference, in my opinion, is one is public and the other one is private. Now let's consider mediation. Mediation is a process where disputants engage in an independent and impartial third party. And once again, this doesn't have to be somebody trained in the law. It can be somebody that is an expert in their field. For example, a healthcare professional mediating a medical legal matter. But here, that third party assists these two parties to come to a resolve. Basically, assist them to find a solution to their matter. Now, let's look at the difference. In litigation and arbitration, you've got somebody deciding who's right and who's wrong. In mediation, the parties would come up with the solution. They would then decide what is the best outcome. So in mediation, we find in more than 95% of the cases, it becomes a win-win situation where both parties feel like they've got something out of the process. And in my experience of mediation, you find that it provides an opportunity for the parties to restore their relationships. And this is quite crucial. I've managed to mediate family matters, divorce cases, where there was custody battles of kids, business matters where businesses want to dissolve. And when we look at history, when business matters go, or business partnerships, I should say, go south, or when family matters go south and one person is adjudicated to be right and wrong, those guys never ever restore their relationship. Now let's consider a divorce matter where a custody battle or a divorce matter has to occur. And of course, we take it to court and the judge adjudicates, and one person's given more benefit than the other. Those two people, whether it's husband and wife or husband and husband or wife and wife, they remain in conflict for the duration of their lives because there was no attempt to repair their relationship. And if you can imagine, what if there were children involved? I mean, we see this time and time again in the divorce matters that come through court. I mean, even maybe in our personal lives or that of our families, where husband and wife can't see eye to eye, the poor kid is used as a leverage mechanism, a bargaining chip. Poor little kid doesn't know, where to turn. And really, it becomes ugly. For the want of a better word, it becomes ugly. Whereas cases that we mediate, we find that the parents can actually have a relationship. Yes, not romantic and even not very friendly, but more tolerable. And in fact, on speaking terms, where they make mutual decisions for the benefit of the child. And we believe that this type of conflict resolution has the best outcomes, right, for all the parties involved. So the process is also very confidential, so it's held in a private sessions or private rooms, and it is consensual, which means that both parties have to agree to enter into this process of mediation, and both parties have to be open to the process. And for those of you that have trained in the process, I know that Dr. Mokhani has, and Dr. Palester, the other one has, and there's a few others. I believe I saw Dr. Des Lyons on the call, who've been trained in mediation. And they would also tell you that the process is completely voluntary, and it allows for people to really put their ideas and their views and their concerns on the table without being prejudiced, without it being set in stone, and you can use it in judgments. And really, it provides a safe environment for people to come up with ideas and really, come to concessions and make concessions so that a solution can come to the fore. Now, you do get three types of mediation, and I don't want to spend too much time here, but you do get a type of mediation where the mediator does judge. We call it adjudicative mediation. We don't really like that type of mediation because it really opens the mediator up for liability, especially if there's an undersettlement or if they don't apply the law correctly and so on. Then you get evaluative mediation. And basically in evaluative mediation, it's a process where the disputants engage in an independent independent and impartial third party that assists them to resolve the conflict. But here there is assisted negotiations, which means that the mediator kind of gives advice to the parties and directs them into a decision. All right. So it is far better than adjudicative mediation, but it does have its limitations, of course, and of course its flaws, especially if the mediator is not too au fait with what the terms of settlement involves and so on. So it is better, but of course the best one that we found, especially in medical legal matters, is this type of mediation, which is called facilitative mediation. So adjudicative, the mediator judges. Evaluative, the mediator guides the party to come to a decision. Now, in facilitative mediation, right, it's a process where the disputants engage an independent and impartial third party that assists them to resolve conflict. But here's the best part, right? The mediator does not give any advice or does not steer the party in any way regarding liability. Here, all the mediator does is very scientifically helps the two parties to connect certain dots, and the parties then come up with a solution. Now, how cool is this, guys? The parties come up with a solution themselves that they both agree to, that they both like, and that they are both comfortable with. Win-win situation. Now, it seems almost impossible, but for those of the guys that have done the course, We've seen it in various different role plays, but real life matters as well. How these matters are so easily resolved once you address the dignity violations and you get the people apologizing to each other and restoring each other's dignity. The solutions just come out like that. The conflict just gets resolved in the matter of, I would say, hours, and people come really to the party with viable solutions. It's not I want. It's more a solution that we get. And we've seen this in thousands and thousands of mediations where both parties actually come out with a win-win scenario. So what's the benefits of this facilitative mediation? I don't want to spend too much time here, but basically we said you can intervene as early as possible. We allow each other to, or each party to address dignity violations. Most importantly for us, relationships are restored. The parties find their own solutions. Nobody's guided and nobody is forced into anything. The solutions are based on future needs, interests, and concerns, not on the past. And you get one mediator. And basically with the one mediator, there's no need for expert medical advice. There's no need for legal expertise and so on. And if you can imagine, if one person, the mediator, is controlling the process, the costs is severely reduced. The time is severely reduced as well. Of course, here we go. It takes less time. It costs far less. And the outcomes are accepted without duress. So nobody is forced into accepting the outcome. So, for example, in a court of law, when the judge bangs that gavel or the hammer, whatever you call it, and says, "You are right, sir, and you are wrong," the party has to accept it, whether they like it or not. When it comes to mediation, there is no duress. So the parties accept the outcome on their own accord, and they buy into the concept of a solution. And of course, they are in charge of the outcome. All the mediator does is very scientifically navigate them to a point where they come up with ideas for a solution. Of course, it is low-cost, high-value solutions. And I'm going to share with you a real-life litigation case versus a real-life mediation case. And you guys will be able to determine which one became more beneficial at the end. And of course, the mediation process cannot be challenged. So once a settlement has been reached and it's been reduced into writing, then of course it's a legal binding document, and both parties have now bought into it. We cannot change it later. You cannot challenge it later. Once a settlement has been reached, that's it. It's done and it's dusted. All right. And most importantly, mediators cannot be held liable for damages. And this is quite something new in South Africa, especially with the implementation of what they call Rule 41A, where the courts of South Africa says that before you attempt litigation, you must try to resolve this conflict with some other mechanism of dispute resolution. And of course, the most viable one is mediation. However, what we started to see is that untrained mediators or wannabe mediators, for the want of a better word, who don't have their party's best interest at heart, basically steer that mediation into a very poor outcome. And up until now, there was no recourse for these individuals. But that's soon about to change because a national regulatory body for mediators is now being formed, and mediators will be held liable for damages if they ill-advise the disputants or the parties. All right. Basically, if you look at what's the difference between litigation, arbitration, and mediation, here in litigation, the outcome is imposed by a third party, whether it's a judge or somebody that sits at the CCMA or whatever. In mediation, the outcome is determined by the parties themselves. In litigation, the outcome is based on legal rights. In mediation, the outcome is based on needs, interests, and concerns. In litigation, only one party can win, right? In mediation, both parties try to achieve a win-win solution. Litigation has been shown to destroy people and their relationships. We've seen this, divorce cases, business matters. But in mediation, one of the core purposes is to try and maintain each other's dignity, and more importantly, to restore or maintain those relationships. In litigation, we find it's a one action and lump sum rule. In mediation, for those of the guys that have trained in it, you'll know that there are unlimited solutions. It doesn't have to involve money at all right? And I'll share with you some of the real cases, I think, in my next 2 slides. When it comes to litigation, the one thing that you have to know is that it is really time consuming, especially given the backlog in our South African courts and the time that it takes to find legal experts and so on. It takes extremely long time and it's extremely expensive. Whereas if you compare it to mediation, mediation is really quick. So for example, a matter that took 10 years to resolve took a team, including myself, 1 to 2 days to resolve. It could cost up to millions in the court of law. And when we applied that same fees to the mediation, it cost less than 1%. All right, so it's really chalk and cheese when it comes to time and money. So let's consider these 2 cases that I was speaking about. And this is really where I want you guys to apply your understanding of justice to the outcomes of these matters, and then look at what happened when we mediated very similar cases. So the 2 cases that I'm going to speak about is public knowledge, and therefore you can find it on any search engine. In the public health sector, it was AD and IB versus the MEC for Health and Social Development. That was in Cape Town. And of course, in the private sector, there was a case which was Chupakan and Levi versus Minnie, who was a patient. So 2 doctors versus a patient. Now let's look at what happened. In the first one, the public health care sector, basically a child was born at Mowbray Maternity Hospital on the 12th of Jan 2009. The mother and child was discharged after an uneventful birth. 4 days later, the baby showed signs of jaundice and was readmitted on the 16th of January. By the time of discharge on the 22nd of January 2009, the baby had suffered irreversible brain damage, resulting in cerebral palsy. The parents issued summons on basis that the hospital failed to diagnose and treat the jaundice timely. And hear this, the hospital conceded merits. So, in this whole case, the baby was born, discharged, the baby was jaundice, had come back to the hospital, readmitted, diagnosed with jaundice, was irreversible, brain damage, cerebral palsy. It's quite common, we've seen it. The parents issued summons. The hospital was negligent in that it failed to treat the jaundice, and the hospital said, yes, it was our fault. We did not diagnose it early enough. We did not treat it early. So they said, yes, we're guilty. The only thing that needed to be now negotiated was how much that hospital was needing to pay this family for their child who was now a cerebral palsy kid. Anybody want to guess how long it took? All right, I'll share. Oh, the time taken from incident to judgment, ladies and gentlemen, my dear friends, took 8 years. 8 years. The hospital said they were guilty, but by the time taken for the judge to say, this is how much we are going to give, it took 8 years in court. Now, for those of you that do know about cerebral palsy, we know that if there's early intervention, we can rehabilitate that kid fairly well, and they can have a very good quality of life. If early intervention is given or provided, and of course, we say it's within the first 2 to 3 years. Now, 8 years later, this poor kid had no chance, all right? Because it took 8 years for them to decide how much the hospital was going to give this family. They engaged 37 experts, 37 doctors, 37 lawyers and advocates, and so on, into this matter. All right? And the one thing I remember from this case is that the judge said, it is really disconcerting how one set of doctors are for the hospital and the other set of doctors are for the family that are claiming negligence. And it is so concerning that both of them are medically trained, and both of their testimonies are so different. And he said, could it be that these medical experts, for the want of a better word, vie for the party that they are called to represent? Do they sway their medical opinion to favor the party they are representing? And if anybody has seen these matters in court, we know that this happens all the time. In fact, some clinicians actually make a career out of being expert witnesses in court. Of course, the duration of the trial and argument in court alone took 51 days. 51 days in a court of law. All right? And of course, after time, the judge ruled in favor of the family, of course, and awarded 17 million rand. Seems a lot, but watch this. The cost of this matter was 14 to 16 million rand. So how much did that family get after 8 years to look after that poor cerebral palsy kid for the rest of his life? About 2 million, if they were lucky, 1 to 2 million. Yeah. After 8 years of all of that trauma that those poor parents and that poor kid was put through in court, after all that time, right, they were awarded 17, but the cost of litigation was about 14 to 16. The family got about 1 million rand to look after that kid for the rest of their lives. Guess what happened? That money got paid from the Department of Health. That poor kid could not survive on that 1 million rand grant, whatever the case may be, or amount. They ended up back in public care anyway, and we still started paying for that child's rehabilitation. So we took the 17 million, gave it to the lawyers, and then still treated the child in the public hospital anyway. Now, when we looked at mediation, it would have cost less than 0.25% to resolve this matter. Now, I want to relate this directly to a case that I was involved in the Eastern Cape. All right. So it was a case that I mediated, and it forms one of the role plays actually in our training. But yeah, basically over the Easter weekend in Eastern Cape, there was a pregnancy or a mother that was about to deliver. She was a really tiny lady. The baby was about 3.7 kgs. The doctors were busy because, as you know, in the Eastern Cape over the Easter weekend, a lot of trauma, road accidents, gunshot wounds and stabbings and so on. And so the birth started to proceed. And of course, the baby could not fit through the vaginal canal and was asphyxiated. And that child ended up with a cerebral palsy. All right. So once again, in this matter, the hospital comes to the fore and says, yes, we were busy. There were no clinicians available. Yes, we should have considered a C-section, given the patient's size and all of this. And we know that we are guilty here. So let's decide how much we need to give the family. And that matter started following the exact same route as this case. And 1 year into the matter, where there was no resolve, they already engaged with a few medical experts and already spent about 3 days in court. One of the best mediators in the country, Advocate Alan Nelson, asked me if I would like to take on this case as a mediation as part of my advanced training. So 1 year later, no resolve. I managed to have a pre-mediation with the hospital and with the family. It was a mother, wife, and a kid. All right. And we sat down around a mediation table and we started mediating the matter. And here's a few things that I found. I found firstly that the mother was concerned because she had no idea what cerebral palsy was about and how to look after a cerebral palsy kid. The father worked in construction, or he had his own little construction business, and he had to sell his vehicle to start paying for the costs of his kid's treatment. And of course, because he had no vehicle, he wasn't getting enough work, and it resulted in them having less income. The strain that it put on the parents, so the mother and father having the cerebral palsy kid, they were a young couple as well, started fighting, and they were almost on the brink of filing for a divorce. The father, unfortunately, turned to booze, so he turned into alcoholism as his means of escaping his reality. And so that's where I found this case. 1 year after the hospital conceded that it was their fault. Now, consider this. After mediating for about 6 hours, I would say, so 4 hours on the first day, and really the second day, 2 hours, and that was merely to look at the solutions and how we can make it work. Here's what happened. On that matter, right, we found that there was a special treatment facility very close to where the family lived in the Eastern Cape that the child could be put into and receive the best possible care for cerebral palsy. All right, it was a government facility, and of course, it would have cost nothing, well, not nothing, but very little to have that child in that facility. The next thing we found is that that specific facility required a kitchen lady, all right, because their current kitchen lady had to leave and so on. So we negotiated with the facility for the mother of the cerebral palsy child to get a job in the kitchen. And of course, she could see a kid at any given time, and she was getting a bit of money. The hospital had an old vehicle that was a bakkie that they were going to kind of get rid of. We negotiated with the hospital to write it off and give it to the father to start his business again. We negotiated with the psychologist in the hospital to chat to the parents and offer them marriage counseling. And we got the father into an AA program, and that was it. Done. Both parties came to an agreement that that's all they needed. It took 6 hours. It took, it took a bit of innovation, and that was it. Win-win situation. Everybody's came out with something that they wanted. The parents were happy. The hospital was happy. No reputational damage. And that was the power of the mediation there. Now, I want to ask you, if you had to apply the definition of justice to the both cases that I just spoke about, the first one being the one on the screen with the MEC for health, and of course the second one, the one that I spoke about, I'm not allowed to share the details because mediation is confidential. But from those two cases, which one of them had a just outcome? Which one was morally right and fair? Yep, I don't need you to answer it. We all know the mediation produced a morally right and fair outcome that was a win-win to both parties. So I'll take you to the next one very quickly. I know my time's running out and I get carried away when it comes to these things. I'm not gonna, this was the slide where the judge said, isn't it shocking that both medical experts can favor the parties they represent? Ridiculous. All right, let's go on to a matter that happened in the private sector. This was a matter that happened up in the Western Cape. It was two doctors, Chupakan and Levi, versus a patient, which was Minnie. Basically, this patient suffered from something very rare. They call it a stroke in evolution. And the two general practitioners that examined her did not diagnose this condition. All right? And they didn't diagnose the condition. The patient was not admitted into hospital, or the patient was not referred to a specialist. Then, of course, the matter was taken to court, and the High Court of South Africa held the GPs liable. Said, yes, you guys failed to detect it. You are liable. You are at risk. for a lawsuit here, or you are liable, sorry, for the claims. And so it was awarded in the patient's favor. Of course, the doctor says no, but this was really something that we could not detect. And then they took it to what they call the Supreme Court of Appeal. So they appealed this matter, right? They took it to the Supreme Court of Appeal. And the Supreme Court of Appeal, they ruled in the favor of the doctors. It said that, no, there's no way that the doctors can be held liable for this condition. The rare stroke in evolution, it's difficult for them to diagnose. And so now the doctors are not guilty. Sorry, Ms. Minnie, but unfortunately, your claim is now dissolved. Now, that seems quite cool, man. So GPs weren't held liable. Of course, we are in the favors of our colleagues, the clinicians. I want to ask you guys, how long do you think it took for the Supreme Court of Appeal to come up with this finding of non-negligence on the two doctors, Dr. Chapaikin and Levi? I'll tell you, it took 10 years. Just on the merits alone, it took 10 years for them to come to this conclusion that the doctors were not negligent. I know personally of this matter because, once again, the gentleman that mentors me managed to meet both these doctors and ask them what would have happened if they mediated it. It was part of a case study. And we know for one thing, one of the doctors turned to substance abuse in that 10 years and stopped practicing anyway. The other one had to move to a little town and open up a smaller practice, of course, lesser income, in a town where nobody really knew of his past and his history. All right? So that's one matter. I would talk to you about another matter that I recently mediated. And this is also one of the role plays, or very similar to one of the role plays, I should say, that we do at the mediation training, where a patient was on the table going for a routine endoscope. And while they were undergoing the endoscope, the patient started to suffer a heart attack. So the doctor immediately stopped the procedure, took the patient in his own vehicle to a hospital and managed to save a life. All right. So the patient came out, the patient was saved, but they did not complete the endoscope. And of course, the patient that went for the endoscope was struggling with digestion and bowel movement. And when they removed the endoscope, the machine itself prints out a report, and the report that the machine printed out, because it was cancer early, was no cancer detected. All right. Now you can see where this case is going. Unfortunately, the patient did have colon cancer, and 2 years later had to go to hospital and have the colon removed, and now had a colostomy bag. That patient sued the doctor, saying that the doctor failed to diagnose the cancer. And of course, it's because of his negligence that she now has this humiliating thing, the colostomy bag, and all her colleagues are talking about her. Oh, she was a nurse, by the way. And so, once again, taken it to the High Court, and the High Court found the doctor negligent. All right. And at this point, about a couple of months after, I was asked to jump on the mediation. And we took on the mediation. And once again, it took, I think, less than 5 hours. And in that 5 hours, we managed to help both parties understand what their dignity violations were. So the doctor was being ridiculed amongst his peers and colleagues in the hospital because they worked very close to each other, or his practice was very close to the hospital. The poor nurse, she had a quality of life change because of the colostomy bag. And I'll tell you how the solution came about. It's quite interesting. All the doctor wanted, by the way, was an apology to say that he was not negligent and he was not this cold-hearted clinician that she made him out to be. But of course, she only did that because in her mind, this doctor was negligent. what we started finding out during the mediation is that she was writing a book and she really wanted time out and she liked horses. And believe it or not, this doctor owned a little, like a boutique hotel, and he had some horses, and he arranged for her to go there and write a book, and that was it. And arranged for her to have a treatment. One of his friends could do a bit of a treatment on her, corrective surgery, and that was it. The best thing for me about that mediation, by the way, was after this doctor and this nurse were in conflict for more than 6 months, where they couldn't see eye to eye. After the mediation, they were both walking out arm in arm like this, like two old mates going off to have a celebratory drink together. That is the power of mediation. Now, I do know my time is ending at 4 o'clock. I just want to quickly close by saying that facilitative mediation is a far better way of achieving justice than litigation is. I'm not going to go through the essential features. For anybody that does want to find out more, you guys can have a look at our website, and the website will tell you a lot about the mediation process and how it works, how you guys can become mediators as well. One thing quite interesting that I want to share in the next minute or so before my time's up is that based on, in fact, Dr. Des Lyons' recommendation, what happens after the mediation course, we had an advanced course, and we came up with a clause that we would like to see more and more hospitals put on their admission forms. And it says that in any event or claim arising from negligence or something thereof, that before they go to litigation, they must first try and enter a pre-mediation meeting with an accredited mediator. And that will almost always rule out the ambulance chasers and the attorneys that are pushing for litigation. So mediation is the better option. You guys already heard why. I'm not going to share that. I want to end by saying thank you very much to Dr. Palesa and her team for allowing me this hour to chat to you guys about mediation. Like I said, it's something that we are passionate about because we see a way of it reducing medical legal litigation in the country, and of course, allowing us to have enough money to treat our patients better and more fairly. With that, thank you very much for your time. I'm not too sure, Palesa, if you want to open the floor up for any questions. I do know it's 4 o'clock on the dot.
Yes, please. No, if we can open up the floor for questions. If you look at the chat, there's a very long note, which, can you read it, or do you want me to read it?
I can't see anything on the chat.
I'm going to quickly read it to you.
Yes.
It's from Wits Anesthesia. It reads, is the sheer burden of the cases that we have all the time taken into account? For example, at Barra, there are 2 obstetric theatres running 24 hours a day, but we permanently have 5 to 10 or more fetal distresses waiting for theatre. Whose fault is it really if children are then delivered with hypoxic injuries? And is it fair to be able to sue for damages in these instances? No negligence occurs, it's simply too few resources. And then second, the shark-like behavior of lawyers should be regulated. To take 50% or more of the award on the no-win, no-fee basis is surely unethical.
Agreed. All right, so thanks for the question. And I must say, you guys at Barra are doing a phenomenal job. We've had similar situations at Groote Schuur. We have similar situations at Mowbray Maternity. Guys, the harsh reality is that with more than half the country's medical budget tied up in medical legal litigation, the situation is not going to better itself, purely because you guys know that there's no budget for more clinicians and practitioners. Guys that are practicing in public healthcare are constantly burdened with this and are therefore moving into private sector. It's something that's not going to be resolved unless we tackle the root cause of the problem. And here, the root cause is the rise in litigation. I showed you right in the beginning that cycle of negligence causing reduced budget, and the reduced budget means fewer doctors, fewer tables, fewer everything. And yes, like you rightfully said, there's 2 of you, but there's 5 cases waiting, purely because there's not enough money to get the 5 clinicians, to get the more tables or functioning theaters. So I reckon that the only way to do this, guys, is a concerted effort amongst the practitioners and lawyers and everyone in the like for the benefit of the medical field, is to start tackling medical legal litigation at its root cause. And by inserting that clause, the one that I just showed you very briefly, and I'm happy to share it with any one of you and tell you how that clause came about, is basically that clause almost not prevents, because you can't take away people's constitutional right to going to court, but it prevents them from immediately engaging lawyers to litigate. It allows them to now go into a forum where they can be told about mediation. And in this forum, they get what we call a reality check. A reality check is, this is how much it's going to cost you. This is how much the lawyers are going to take. This is how much you're going to be awarded. This is how long it's going to take. And in that time, we use it clinically and scientifically to persuade the parties to enter into a mediation. And believe it or not, there is a study that's done now in the UK where they show that mediation can reduce medical legal claims by 60%. Now, if we had to take 60% of 118 billion rand, there's your extra clinicians right there. There's your extra equipment and theater tables right there. I know what's Barra's amount for medical legal litigation. It is shocking. It is shocking. So here's the money. All right.
Shubhanu, there's another question. Once the two parties have agreed to the outcomes decided in the mediation, if they are not happy with the outcome sometime in the future, can they still pursue litigation? Do they sign some sort of legal document to accept the outcome of the mediation and prevent them from litigating later on?
Correct. So remember we said that once the parties enter into a mediation and they come to an agreement, all right, and the agreement is reduced into a legal consent or a legal agreement in writing signed by both, then they cannot litigate unless they find another avenue to litigate. So something else along the matter which they litigate to. But once they have a signed agreement where both parties agree that we have resolved this matter, it is legal and it is binding. All right. So yes, very good question. Once they've resolved it and they've reduced it into a settlement and it is signed, they cannot litigate further unless they find another way of bringing in a lawsuit.
Last question. Should the government or ruling party be held directly accountable for cases like fetal distress, waiting for theatre longer due to no resources? So one theatre with 5 fetal distresses. Now instead, healthcare staff are exposed to the trauma of legal issues for that time being, for something that's potentially out of their control.
Our government.
Yes.
Guys, you guys work in healthcare. You guys live in South Africa. Our government has no accountability. There is no accountability from the top down, right? And so we are fighting to get more clinicians to help us. And yet the government turns a blind eye. Look at our previous Minister of Health. Get a slap over the wrist for the PPE scandal. There is no accountability. So by us saying, should the government be held responsible? It's not going to happen, right? Yes, they should be held responsible. Yes, it's their fault, all right? But of course, remember, if we continue on this blame game, nothing is going to happen. Nothing's going to get better. All we have to do is we have to realize that this problem is going to cripple healthcare. And if we rely on the government to fix it for us, we are all going to be jobless, or South Africa is going to have an extremely morbid population. What do we need to do? We need to become advocates and champions for mediators. We need to put pressure on our hospital administration teams to say that Rule 41A has now been passed in the Constitutional Court, which means that any matter needs to be first mediated before litigated. Let's start putting pressure to have these clauses in our admission forms. Let's start to make our PRO officers aware that there is an alternate mechanism for dispute resolution. It doesn't have to go the legal route. Let's give mediation a chance. I promise you, with the number of trained mediators we have in the country, we can tackle this issue in less than a few years, not the few decades that our current ministers are predicting.
Shamal, thank you so very much. Before any more questions come in, if you want information, training, or anything involved with mediation, Shamal has given you his email. You can also Google the site Mediation in Motion. It's fantastic. I think at least 6 to 10 anesthetists within the department have gone through mediation. And it's something I think we can even apply to our day-to-day conflicts with either each other or even the surgeons. So valuable, highly valuable. Shamal, thank you.
Cheers, everyone. Enjoy your afternoon further and enjoy your conference. Ciao.
We
Bye-bye.
will do. Bye.
Can I just make a comment before you go, Shamal, if I may?
Of course.
You know, your definition of justice, unfortunately or fortunately, includes the word morality. Now, morality differs in different societies. In our plural ethnic society, morality differs amongst various groups. So I think it's in fact dangerous, I think, to include morality in your definition of justice. It varies over time, it varies among different groups. And how do you overcome that problem when it comes to mediation concept? The other comment I'd like to make, a very well known divorce lawyer friend of mine once said to me, he is only happy in divorce cases when both parties walk away unhappy. That means there's compromises being done. What do you think of those two comments?
Yep. Thanks, Dr. Brenner. We have a similar saying where when both parties walk away unhappy, it means it was a successful mediation. So very similar. Just to take you back to your comment right in the beginning about the moral aspect. Remember, that's the textbook definition of what justice is. Your application of the law to achieve something that is morally right and fair in accordance with the law. I agree fully that, you know, in South Africa, moral means different, or ethics means different for different people. But believe it or not, before our law system, which basically mimics the colonial systems that were brought to us by the British, we had, I'm talking about the South African population, mediation was the only form of conflict resolution. It used to be a senior or an elder from the village that sits under a tree and gets both the parties in and gets them to engage in a conversation. Once we've been colonialized, or for the want of a better word, taken over, they started applying their law systems to us. And that is why it doesn't apply, or doesn't work, I should say, here in South Africa, because we're applying a different country's system into ours. Our rightful way of conflict resolution is through negotiation and through engaging with each party. Thank you very much for that. I agree fully. The definition we can't change, it's in the textbook, but your understanding of moral is exactly what we contest all the time. Thanks very much.
Thank you for an excellent talk. Thank you.
Pleasure. Cheers, everyone.
Bye, Shamal.
Hi, everyone. Silvio, you can log off.
Palesa, I'll make you the host and keep this meeting running.
Yeah, sure.
Okay, cool.